International workers, confusion around payment of Provident Fund. International workers, Indian PF compliance. In October 2008, the concept of an international worker was inserted under paragraph 83 of the EPF scheme. An international worker is defined as a person holding a foreign passport working for an establishment in India. The scheme prescribed that PF shall be applicable to international workers on their full salary without any wage ceiling. The only exemption has been provided to employees from countries with whom India has signed a social security agreement. However, certain recent judgments in 2024 have raised a controversy on applicability of PF for IW. The Supreme Court, in the indirect tax case of Bangalore, adjudication versus Northern Operating Systems Private Limited, held that secondment of employees is in the nature of manpower supply and not employment. In other words, foreign employees working with an Indian company will not be considered to be employees of the Indian company. This judgment of the Supreme Court has far-reaching implications beyond the realm of indirect tax laws, as if an international worker is not considered to be an employee of an Indian company, it unfastens the liability on the company to contribute to PF of the international workers. The courts are yet to test the argument of dual employment and implications of the same in the case of international workers. Karnataka High Court on applicability of PF provisions to expats. In April 2024, the Karnataka High Court, in the case of Stonehill Education Foundation vs Union of India and others, struck down Para 83 of the Employees Provident Fund Scheme, 1995 as unconstitutional and arbitrary, as the provisions are vocative of Article 14 of the Indian Constitution. The court held that international workers drawing higher salaries cannot be forced to contribute towards PF on their entire salary without any wage ceiling, while a wage ceiling of 15,000 has been prescribed for domestic workers. Karnataka High Court on applicability of PF provisions to expats. It is a settled position of law that any High Court's decision with respect to a central legislation has a binding effect on all other High Courts in the country unless it is stayed or overruled by the Supreme Court. In light of the same, the provisions with respect to payment of PF on salaries of international workers stand struck down as on date way forward. These judicial precedents with respect to international workers has created a contradiction on the position of law with respect to PF payment to international workers. On one hand, there are ongoing inquiries on the payment and quantum of payment of PF on the salaries of international workers. On the other hand, the requirement to pay PF on the wages to international workers has been struck down by the Karnataka High Court judgment, and the employee status of an international worker was disregarded by the Supreme Court in tax matters. This contradiction in the position of law creates ambiguity on the compliance requirements from the companies. More clarity is awaited when pending matters are heard by the Supreme Court. Any question, ask C-Quel.